So here's where things stand right now. Donald Trump is watching as federal marshals begin the formal process of taking control of his properties. And the judge overseeing this case didn't just dismiss his legal challenges, she dismantled them piece by piece in an opinion so severe that veteran legal observers are calling it one of the harshest rulings ever issued against a former president. What sparked this financial freefall? Trump's own attorneys filed last-minute emergency motions arguing that the asset seizures were unconstitutional, politically driven, and would cause permanent damage to his business empire. The judge's response was blunt. She labeled the arguments frivolous, legally unsupported, and an affront to the court itself. This goes far beyond a wealthy developer losing a few buildings. What we're seeing is the systematic unraveling of the Trump organization's most prized assets, properties that have defined Trump's brand and public image for decades. These buildings are now being inventoried, assessed, and positioned for seizure to satisfy an enormous civil fraud judgment. When court officials begin evaluating properties like Trump Tower or 40 Wall Street, the idea of legal accountability becomes impossible to ignore. A business empire built over half a century long, promoted as proof of Trump's genius, is now at risk of collapsing because of years of inflated valuations and misleading financial statements. Here's how we got here. This case originates from New York Attorney General Letitia James's sweeping civil fraud investigation into Donald Trump, his adult children, and the Trump Organization. For years, investigators examined claims that Trump routinely exaggerated property values to obtain favorable loans and insurance, while minimizing those same values when reporting taxes. These weren't minor differences. Investigators found that Trump overstated the size of his Manhattan penthouse by nearly 3 times its actual square footage, assigned wildly inflated values to Mar-a-Lago, and manipulated appraisals across his real estate portfolio. The court concluded this wasn't accidental, it was deliberate and persistent. After a trial in late 2023, the judge ruled that Trump engaged in repeated fraud over decades. In early 2024, the court issued a judgment exceeding $450 million, including interest, and ordered Trump to surrender profits gained through fraudulent conduct. Trump immediately appealed, but under New York law, appealing doesn't pause enforcement unless the defendant posts a bond covering the full judgment. That meant Trump needed to secure nearly $500 million in cash or acceptable collateral to stop asset seizures. According to reporting at the time, Trump's legal team contacted more than 30 bonding companies. None were willing to underwrite a bond using Trump's real estate as collateral. The reason was painfully clear. The same court case proved Trump's valuations couldn't be trusted, and financial institutions weren't willing to take that risk. Let's be honest, asset seizures don't happen to former presidents or supposed billionaires who actually have the money they claim. They happen when courts have exhausted patience, when judgments are final, and when the defendant cannot or will not pay. That alone says everything about the gap between Trump's image and his actual financial reality. This week, the seizure process began in earnest. State attorneys, federal marshals, and court-appointed receivers began arriving at Trump properties with court orders. At 40 Wall Street, officials entered the building to inventory assets and establish oversight. At Seven Springs, Trump's Westchester estate, court-approved appraisers began formal evaluations. Even Trump Tower, long synonymous with Trump's personal brand, was subjected to initial assessments to determine how it could be used to satisfy the judgment. Trump's lawyers fought back hard. They argued that seizing properties would harm tenants, employees, and businesses. They claimed the case was politically motivated, pointing to campaign rhetoric by the Attorney General. They argued enforcement before appeals were complete, violated due process. The judge rejected every argument. In a ruling that legal analysts described as unusually direct, the court stated that Trump had already received full due process. He had a trial. He had representation. He presented evidence. He lost. The judgment wasn't a surprise. It was the direct consequence of proven misconduct. The court addressed Trump's claim of irreparable harm by pointing out the obvious. The harm was self-inflicted. If Trump wanted to stop enforcement, he could have posted the required bond. His failure to do so was not the court's responsibility. The ruling went further. The judge directly confronted Trump's claims of political persecution, stating that suggesting the entire New York justice system was conspiring against him was unsupported by evidence and deeply disrespectful to the judicial process. The court noted a repeated pattern of bad faith litigation tactics designed to delay accountability rather than seek justice. This pattern isn't new. We've seen it in Trump's response to the classified documents case denial, defiance, delay. We saw it after January 6th, claims of immunity, obstruction, endless appeals. We saw it in the Jean Carroll cases, defamation, judgments, refusal to accept responsibility, followed by more defamation and more penalties. Even before politics, Trump's business model often relied on refusing to pay contractors, dragging disputes out in court, and forcing settlements through exhaustion. That strategy works against small businesses. It doesn't work against governments. Now, Trump has reached the point where every legal option has been tried and rejected. Appeals are ongoing, but without a bond, enforcement continues. That's how civil judgments function. Legal experts say this moment represents a collision between Trump's public persona and legal reality. For decades, he portrayed himself as a master dealmaker and billionaire. Now, a court has ruled that much of that image was built on falsehoods, and the market has confirmed it by refusing to accept his assets as reliable collateral. The consequences are enormous. Financially, Trump could lose iconic properties central to his brand. Beyond that, lenders tied to other Trump properties may invoke default clauses, triggering a cascade of financial trouble across his entire portfolio. Politically, the optics are devastating. A man who built his political identity on business success is now watching his assets seized for fraud. That's not a narrative easily dismissed as persecution, especially for undecided voters. Institutionally, the case sends a powerful message. Political power does not exempt anyone from financial accountability. Fraud has consequences. Judgments matter. Courts enforce them. Within Trump's base, reactions are fractured. Some are calling for confrontation. Others privately acknowledge the damage this does to Trump's credibility. A third group attempts to criticize the process while distancing themselves from Trump's decisions, but that position becomes harder to maintain as seizures continue. Trump himself has responded predictably, attacking the judge and the attorney general and framing the case as an attack on conservatives, but the facts remain stubborn. The judgment exists because fraud was proven. The seizures exist because Trump couldn't secure a bond. This isn't persecution. It's accountability. And that's what makes this moment so significant. If Trump ultimately avoids consequences, it would signal that financial fraud is tolerable for the powerful. But if enforcement continues, it reinforces a foundational principle. No one is above the law. Right now, the process is moving forward. Properties are being evaluated. Appeals continue without a stay. And the image of Trump's empire under court control may reshape political and legal conversations for years to come. This isn't just a legal story, it's a reckoning with facts, with accountability, and with reality.